So we are ready for our panel called The State and Future of SEC Crypto Enforcement and Regulation. The moderator is Peter Altman. We've already introduced Peter, but he's a partner at Akin. And Peter, you're doing a great job on the introductions. Keep it up, please. Trace Schmeltz is with us, a partner at Barnes & Thornburg. He is based in the Chicago and D.C. offices, and he's the Financial and Regulatory Litigation Group Chair and FinTech Chair at the firm. And his litigation focuses on complex commodities, securities, M&A, and white-collar litigation. Welcome, Trace. From the SEC, we have Brent Wilner, an associate director in the SEC's LA regional office. He's been with the Enforcement Division for nearly 11 years, and Brent previously served as Deputy Attorney General for the California Department of Justice. Welcome, Brent. Finally, very pleased to welcome Omid Yazdi, a partner at KPMG's Risk Services practice. He's the co-leader of the firm's Southern California forensic practice, where he leads a national risk analytics specialist team. Omid has over 30 years of international experience assisting KPMG's clients with forensic services, data analytics, litigation support, and more. Omid, very glad to have you with us. Peter, I'm going to turn it over to you.
Thanks so much, Bruce. Great to be back here again, and great to be moderating this panel. We're going to pick up where the lunchtime panel left off, maybe with a little bit less, keep our voices slightly down, and we'll let all of us finish each other's answers.
What fun would that be?
All right. Take it as you'd like. You know, you go with it. Okay, so we're going to start with what can we expect from SEC enforcement, which is sort of, I think, the burning topic. There's a lot of interesting policy debate out there about what's going on, where are we going to go. But I'm kind of focused on like what actually is going to be happening right now. So we're going to try to give people some practical tips. So Brent, we'll start with you. We've already heard quite a bit today, obviously, about shifting SEC priorities, all the changes that have occurred, and probably all the changes that are still to occur. We heard from the C2, someone on the C2 this morning, the rebranded Crypto Assets and Cyber Unit, and it was notable that in all of the different things that were discussed during that panel, the only thing about crypto that was mentioned was we're still going to be doing fraud cases. So we'll get into that. And of course, we had the benefit of that really lively discussion at the lunch hour. Nick, great job moderating. So much is swirling around. I have actually a very simple question, I think, to kick us off here. You're one of the new associate directors of the LA regional office, an office that oversees a very large geographic area with lots of people involved in the digital asset industry. So from your seat, you can give your disclaimer if you'd like or not. What do you see as the role of SEC enforcement as it pertains to the digital asset industry as of today, May 15th, 2025?
Do you think it would be wise of me after that lunch panel to just speak for the commission, just get up here and riff?
I think you should do as you see fit.
I do have 3 small children, so I'm trying to do this in a way that I still have a job at the end of this presentation. So, no, I really appreciate it. And one thing I just want to say, it's really nice having this event in LA. And the biggest reason in my mind that it's nice is because it allows us to showcase the really talented enforcement staff that we have in our office, that even with all of the changes that you've heard about today, continue every day to come in and do the SEC's mission and make us all proud. So we really appreciate them making their time. I will give the disclaimer just because, which is that my comments today are provided in my official capacity as an associate director in the Division of Enforcement and do not necessarily reflect the views of the commission, the commissioners, or other members of the staff. So I'm going to reset a little bit. I know you obviously heard a lot of crypto at the lunchtime, but I just kind of want to frame, I think, how we're thinking about things now, as you've heard, a month into Chairman Akin's tenure. So it's still early days, right? So we'll continue to see an evolution in how the agency approaches a range of things related to enforcement. That's obviously especially true with how the new commission is going to approach crypto assets, and obviously just in the short time since the inauguration of President Trump has undergone significant change. Just to reset, as we heard during the lunch panel in January, then Acting Chairman Ueda launched a crypto task force led by Commissioner Peirce, and the express goal of that was to develop a comprehensive and clear regulatory framework for crypto assets. And the goal in doing so is to make that the way that the Commission is approaching crypto assets better align with the agency's mission of protecting investors, facilitating capital formation, and maintaining orderly markets. In the short time since Chairman Atkins has been in place, he also has amplified that message. And he has stated that his goal is to coordinate with the administration and with Congress to establish a rational, fit-for-purpose regulatory framework for crypto assets. And I think that phrase, fit for purpose, does a really nice job sort of like summarizing the way that the Commission is approaching this effort. So as part of that effort, the new Commission has made clear that we need to refocus the enforcement approach to crypto assets to complement the task force work. As Acting Chairman Ueda stated in January, we need to deploy enforcement resources judiciously and to address the concern that we've been using enforcement actions to regulate crypto retroactively and reactively, often adopting novel and untested legal interpretations along the way. In several instances, to facilitate this process, we've dismissed pending litigation involving registration claims. And in announcing those actions, the Commission has stated in the press releases for several of those dismissals that the dismissals will facilitate the Commission's ongoing efforts to reform and renew its regulatory approach to the crypto industry. At the same time, the new Commission has made clear that the Enforcement Division will continue to have a vital role to play related to crypto, and in particular in eliminating conduct that involves fraud and manipulation, and especially fraud and manipulation impacting retail investors. As Chairman Akin said in a statement before a meeting of the task force earlier this week, the Commission's enforcement approach will return to Congress's original intent, which is to police violations of these established obligations, particularly as they relate to fraud and manipulation.
So, okay, I think that's a great summary and a good reset, as you said, but just like qualitatively, over the last, call it 5-6 years, there were a lot of cases where the sort of underlying product was alleged to be a digital asset security. And so it seems like we're kind of pressing pause on that. And you're talking about rooting out cases that involve fraud and manipulation. Like, so what kind of enforcement actions are we talking about? Are we talking about sort of the quote unquote steal the money cases that touch the digital asset industry? I saw a case this week where there was an investment offering that was deemed to be or alleged to be fraudulent involving a blockchain-based online casino, which I'd actually love to hear John Reed Stark's whether there's utility to the blockchain for that. But is that really what we're talking about here? That just like your kind of garden variety SEC fraud case, and maybe if crypto's involved, we'll mention it?
Yeah, look, I mean, my answer to almost every question you asked today is going to call for a little bit of patience. I think that's just a necessary component of all this. I think the contours are still being worked out, but I do think a guiding principle will be instances where there has been a real fraud, a real impact on retail investors. How that's going to interplay with the task force's work and sort of itemizing and creating a jurisdictional framework, I think we'll have to wait and see. But I do think a good recent example of the types of cases that we are going to have a lane to bring now, you mentioned the Richard Kim action, which came out yesterday. I actually really, and Amy Longo pointed this case out earlier, I think a great example is PGI Global. And it's a case where there was substantial harm to investors, and it shows that the work that we continue to do in this space is critical to protect those investors when people try to use crypto or sort of the allure of crypto to raise money. So just to give a summary of that case, in April we charged Ramil Palafox, the founder of PGI Global, for a scheme that raised nearly $200 million. And in the context of that fundraising, he misappropriated nearly $60 million of those funds. And Amy Longo already sort of gave away the fun facts where, he spent that money, of course, on Lamborghinis, the usual accoutrements of fraud. But I mean, it's just it's a clear case of where we need to be. We still have a very important role complementing the task force's work by rooting out this type of fraud. So Palafox claimed that PGI was going to do sort of an automated trading system. He was going to pool investors' money and trade in crypto and forex. For some reason, crypto and forex trading schemes sometimes go together. And he used MLM-like referral incentives to recruit new investors. I will note that because I think one of the things that your question tees up is how do we get there within the framework of our jurisdictional our jurisdictional mandate. And I will note that the complaint applied Howey, alleging that PGI Global's membership packages were investment contracts and thus constituted securities under the Securities Act and the Exchange Act.
So that's like the Orange Grove instead of the orange.
Right.
To use the Howey facts.
Right. So the complaint alleged that Palafox led investors to believe that they would receive profits on their package investments through his trading on their behalf. And again, I just want to say, I mean, because this kind of, I think, picks up a little bit where the conversation left off at lunch. This work is important as a complement to what the task force does. It's bad actors like Palafox not only harm investors, but they also negatively impact the ability of legitimate actors in the crypto space to build their businesses. So, it's something that actually can help create sort of a landscape where the administration's goal of supporting the innovation can thrive.
So one more question on just sort of setting the table here. So when we think back over the arc of SEC enforcement in this space over the last 10 or so years, a lot of it flowed from this 2017 Dow report, which is something uttered at probably hundreds of conferences over the last decade, which was a 21A report of investigation, kind of actually a little known sort of tool in the enforcement toolkit. Could we actually see sort of more flexible messaging from enforcement during this transitional period and maybe even beyond? Like, for example, exams will put out risk alerts. They're not sort of publishing, obviously, deficiencies about registrants, but they message out to the community. Do you think we might be seeing enforcement using different tools that it hasn't used in the past?
Yeah, so just on the specifics of the 21A report concept, I think it's too early to tell whether that's going to be sort of the particular tool in the toolkit that enforcement will lean into. I think it's partly going to depend on the types of questions that evolve after the task force completes its work. Just to get in sort of the wonky part of it, right? For those who aren't familiar, 21A reports have historically, they're not a common tool that we've used, but they've historically been used in context where we think the application of the securities laws to bring an enforcement action would be seen as particularly novel or be against the backdrop of a high degree of uncertainty. So we've used them obviously in the Dow report, but business email compromise. This is the main reason Peter asked this question, because he and I both worked on that. So he gets to reminisce on all the awesome stuff he did when he was at the commission.
That's so nice of you to say.
Yeah, no, distinguished career that Peter Altman had.
In the past tense. Ouch.
Yeah.
You're
picking up.
You're welcome to pick it up. Just bring John Reed Stark up. Just bring him up. But look, I mean, I think the broader point is that, again, it's, this theme and this word they'll probably say 16 times is complement, right? Like, I think that the way we think about the way enforcement is going to be acting in the context of crypto with the new administration is to be a complement of the policy work that the task force is doing.
Okay, so stay tuned, I guess, is the bottom line there. All right, let's shift gears a little bit. So this is a topic that came up during the lunch hour, kind of what is the role of past precedent? And I think John was alluding to, 89 pages of his testimony that's replete with all these.
All they did was win.
All they did was win. All they did was win.
Nothing but winning. The greatest winners ever.
I'm not going to engage in that. Okay, so how to think about the role of past precedent in future cases. And then also a sort of secondary topic, this seemingly new era of approachability of SEC staff. So Trace, we'll turn to defense counsel here. One of the things I've really been mulling is like, how is this going to work? Like just as a practical matter. You have lots of cases out there where, as was noted, Article 3 judges have weighed in on tested sets of facts at the summary judgment stage or maybe even at a bench trial, things like that. And they're out there. These are decisions where the time for appeal has passed. I imagine there's plenty of private litigants on both sides, both plaintiff and defense, that are going to be more than happy to be citing cases like Ripple or Coinbase or whatever it might be in making arguments about this is a security, no, this isn't a security. What are we going to do here?
Well, I mean, thankfully, those cases are at odds with one another. I mean, you have enough of the precedent now to have a fight that's principled on either side. But you certainly have a commission under Gensler where anything that you looked at was a security, right? And Hester Peirce is very clear that that's not the case. I mean, the debate about meme coins, right? I mean, it seems sort of silly to me if you took a Pete Rose playing card and you said, I'll pay you $50,000 for that, and we bid it up to some ungodly, stupid number because he's now potentially in the Hall of Fame, he's back in the MLB, and then you meme coin that and it's suddenly a security. Like, right? What are we doing? I think you're going to see a new world in which the attitude of the commission is one towards let's make careful, considered policy. Let's ask people in the industry, is a digitized X a security? Is it at this point in its lifespan a security versus that point? And you're going to see regs and policy around that I think will help leaven the field in this conversation. We'll take the Ripple, the Coinbase type cases and say, here's a better way to think about it, to interpret it on these facts. I think certainly the commission to date has been inviting the industry to come in, inviting conversation around these things with an eye towards real policy. I think you've got, like Dan Gallagher at Robinhood is going to be, as he always is, outspoken and will probably, now that they've just made a big crypto acquisition, will probably be walking in with this white paper of this is the way we want the world to look. And I actually think you're going to see a commission that's going to listen to the industry in a different way than it did in the last administration, which will help, again, leaven how we look at these things and take some disparate, I mean, the fact that you have some Article 3 judges with a little bit different ways of looking at it, right? We're going to get some more consistent policy.
So is the idea there, and maybe this is sort of a administrative law, like final exam question, is the idea there that if you have some big body of case law and the commission then comes out with rules and regulations that somehow that alters the landscape?
Yeah, I mean, perhaps, right? We also don't have administrative deference anymore
right.
for the Supreme Court. But certainly when you have regulations and careful thought, yes, that helps change the landscape, define the landscape. How do you get from this point to that point? Can you harmonize those things?
Leaven the bread. I like that. That was good. So let's stick on the point of the discussion with the staff, because I do think that is something that's really interesting, and you hear it in speeches. It's in the at the crypto task force. There's talk about come on in, talk to us, and it almost seems like a PR campaign. And I think part of Hester Peirce's initial statement that she put out was like, it took a long time to get here. It's going to take us some time to get out of here. And obviously, there's been just tons of staff level guidance. I don't think 20 years of practice have ever seen anything like this, where it's like the meme coin statement, crypto mining, covered stable coins, even guidance about like how issuances of companies that are involved in digital assets in some way. And even just today, I was looking at my phone before we came up here, a statement from Trading and Markets. So it's sort of dizzying in some respects, everything that's coming out of there. What about with enforcement? Do you think that, Trace, that kind of like spills over to enforcement? That would you see them as more of a willing ear earlier in an investigation about your view of the world?
Well, right. Every office is different, and it's going to be relational at some level. Certainly, certainly, our experience so far has been that picking up the phone, even in existing cases, and saying, is this case going to continue, right? With some of the non-named, folks the investigation's been dropped because you made a phone call, you said, hey, what's going on here? And oh yeah, and a couple of days later, we're done with that. So that's been good. I certainly think that if you are with a registration type claim, right, you should feel good about your chances to not have an enforcement action. I think if you're like in a pig butchering scheme, right, that's going to be a problem for you. Like, it doesn't really matter.
How many people in the audience know what pig butchering is?
Right? So there you go. So,
right.
Disappointingly high number of people.
More hands. Go ahead.
But honestly, like those types of things, you're not going to be able to call. But even you think about like Haley Welch, right, the Hawk-Tuah girl, right? That was an accusation of a pump and dump scheme, and that case was dropped. Now, arguably, it was dropped because that's a meme coin; it's not a security. But it's also, boiler room, pump and dump type things have been schemes that get prosecuted all the time. So those kinds of cases, I think, give you some comfort that you at least have a better ear, a more receptive ear now than you've had in the past. And certainly 2-3 years ago, you couldn't put a call in and say, hey, can I talk to you about this crypto case, and feel like it was going to get a really robust conversation. Brent would have a conversation with you, but then I just walk away. That's all.
I'll leave that one hanging. Okay. So, I sort of take it, if you zoom out from all of this, to me, it's like we're in this transitional period, as Brent was describing. And part of me wonders whether this is almost like a honeymoon period, in the sense of like, something's going to happen later that I wonder whether people's sort of don't like what comes out of all of this. And I think that will be an interesting time, maybe this conference next year. By that point, there will have been more guidance, and you may find people in the industry who actually don't like what the guidance is. So I guess, Brent, Trace, we're talking about like right now, but in my experience, even prior to the administration turnover, the staff was open to hearing people, make arguments about Howie. Do you think the division is going to be interested in hearing from people kind of earlier on like crypto-related cases?
Yeah, I think this one I can give a short answer to, which is yes. So, look, in connection with the task force, as you already alluded to, both Chairman Atkins and Commissioner Peirce, and while he was acting chairman, Commissioner Ueda, emphasized the importance on making sure that we are genuinely engaging with relevant stakeholders as the Commission seeks to develop workable rules of the road. I thought Commissioner Peirce sort of had a good summation of this, saying that greater crypto clarity requires the public's input, and input from all stakeholders can significantly aid in that process. It's clearly a sort of trying to create an environment where people from all spectrums, including industry stakeholders, will have a say in sort of how this process plays out. And as part of that, the Commission's website even has a link to a meeting request form where members of the public can request meetings related to the task force's work. I think in terms of how we internalize that messaging in the enforcement division in Los Angeles in particular, these same principles animate us to redouble our efforts for openness in our discussions with respondents, to make sure that we're considering relevant arguments at an early stage in our work. And look, it's always been the case, but I think especially now, we want that message to get out there because, look, it benefits us as well as the respondents to move along our matters efficiently.
Okay. Thumbs up, Trace. You buying?
Listen, we've had very good success getting meetings, having our thoughts heard, and I guess it feels to me like more of a willing ear, as opposed to a begrudging. I don't mean to be. That's going to be like, seriously, I'm going to smack you. But no,
You're doing great, Trace.
I just feel like, and it's helpful, right? When you have guidance out there that says we're pausing this to think about whether things are securities.
Yep.
But let's hope. Yes.
Okay. All right. Shifting topics again. Omid, I'm going to turn to you here. And this is the concept of sort of how do you think about risk mitigation
Right.
if you're a client in the age of transition and some uncertainty about where this is all going? And I can say, within our firm, we're fielding a lot of questions from clients about whether, essentially, has the environment changed already, such that, and this is a bit extreme, but what may have been considered unlawful prior to President Trump taking the oath of office when the sun rose on Inauguration Day, that today that conduct is just permissible.
Yeah.
Like that it's that binary. And I guess I'll just say from my view, obviously the vibe is very different, but I'm still, going back to our discussion about the precedent, not sure the law is like different per se. So from a compliance perspective, is it like time to double down? Is it time to relax? Is it time to just do something different? What do you think?
Yeah, well, it's strange saying this to a group of attorneys, but the law still is the law, right? And what we're going to see with this administration, it's going to evolve, it's going to change with how they're going to enforce their view of the law. But with companies and their compliance programs, they can't just throw everything out the door and say, new administration, we're just going to go with the whatever it gives. Companies are much more conservative than that. I mean, the conversations that people are having here today are much more nuanced. If you're a compliance officer, if you're an internal audit leader, if you're a risk manager, you're looking at your code of conduct, you're looking at your compliance programs around these areas, and you're saying, I'm not sure, I'm not excited about making a lot of changes. And one of the reasons for that is it took a long time for companies, the good clients that we have, to get to this point. Now to take this complete 180 turn and say, well, we're going to ignore those, we're going to do away with those policies. We're not seeing those are not the conversations that I'm having with my clients. The conversations that I'm having are the same with the Tracy's having. It's like, it's a lot easier now to talk to the government. It's easier to deal with residual matters that were hanging over our heads and try to resolve them. But I think if you think about it, 20 years ago, right, under the U.S. federal sentencing guidelines, a lot of companies started creating codes of conduct, policies, processes, because they felt like they had to, because the law required them to do it. I think companies have moved past that, regardless whether it's this administration, and for those of us who study the U.S. history, every couple of 4 years we're going to have a new administration, new political party. They're not. I don't see them kind of throwing out the baby out with the bathwater in terms of what they have put in place. And they made some big investments, right? If you think about the 3 lines of defense and the programs that they have in place, I'm not seeing a big movement. They're all curious and they're cautious, but they're not doing away with their compliance programs and making substantial changes.
You think about it in the context of crypto exchanges that, when they sort of first became a thing a decade ago, a lot of them had very underdeveloped compliance programs. And then over time, it became market standard for people to have real AML programs and do KYC checks and cooperate with law enforcement. That became sort of more of the standard. Now, there's still companies out there that weren't necessarily doing that. But I think the point is, all the companies that built out those compliance programs, I think what you're saying is they're not going to just like pull back now.
Yeah.
Right?
I mean, think about the political, capital that they had to spend to establish those things. Look, we are seeing other changes in the marketplace. Our clients are holding back on big investments, on big, system implementations. The M&A activity has gone down. Those things have impacted our business as a Big Four accounting consulting firm. But we're not seeing a change here. We're not seeing, the calls are still coming in for assistance and assessments of their compliance programs.
So Brent, we're talking a bit abstract here about efforts to be compliant and have policies and procedures, things like that. I guess maybe like trying to think about it more substantively. Like, do you think that concepts of like good faith efforts to comply, do those carry more weight today than maybe they did a few months ago?
I think what I would say is that I think, again, I look at sort of the way that Commissioner Peirce and Chairman Atkins have messaged this task force, and the way that they've communicated how they want to go about this process. And I think that informs how, as an enforcement program, how Gary and I in Los Angeles are going to think about how we respond to those types of arguments. And I think that informs us that we're going to take those types of good faith attempts at compliance seriously and treat them as meaningful things that we evaluate in our actions. I think it's consistent with the goals of the task force, that the enforcement division would consider the efforts of industry participants as we sort of think about how we move forward in our investigations.
Okay, so Trace, we've been obviously focusing on the SEC so far, consistent with the theme of the day. But I think one thing that is becoming very clear over the last few months is not all authorities are sort of created equal right now in the United States, and it seems like there may be some other angles of enforcement that the digital asset industry is going to be having to deal with. So the DOJ, the SEC, CFTC, particularly DOJ and CFTC issuing public statements that they're going to be stepping back on like registration cases, other than a curious carve-out that I think might actually swallow the carve-out unless it's willful. But anyway, we could probably spend some time talking about that. But we have seen some states step out pretty aggressively. Oregon, in particular, filed a very high-profile action a few weeks ago. And I think the general expectation is that there's more is going to follow, unless and until we get to the point of clear federal preemption, which that seems still kind of a little far away. I mean, maybe things move fast, who knows? But what do you think is going to be happening here, state, federal?
Well, listen, American politics are American politics. So you have a Republican administration saying we're going to have less regulation. What do you see around the country? You see states with Democratic administrations saying, oh, no, we're not, right? Oregon comes out, they had a Democratic attorney general. What do? They say, hey, Coinbase, those are securities. You're violating securities laws. We are going to bring a claim under Oregon law. We have cases. I have almost the same case in front of 3 different departments of financial institutions in 3 different states. In the 2 Republican states, we're golden. Nothing's happening. In the Democratic state, we're getting crucified. Like a hearing, like you're going to have a hearing. Here's all the facts. We shouldn't have the hearing. No, we're having the hearing. No, can't we talk settlement? No, we can't talk settlement. Right? It is.
Are they listening to any arguments about like, hey, the SEC has pulled back on this. What are you doing? They say it's not a security.
No, not at all. No, not listening to those arguments. Not listening to arguments that the law. I mean, what you would think is what we've learned is the law that we have doesn't perfectly fit digital assets. And so when you say to a state regulator, the law that you have doesn't perfectly fit digital assets, they go, yeah, don't really care. Administrative law judge is not going to care. We don't care. So companies have to stay compliant, have to stay on their toes, because that existential threat to getting, I mean, if you have money transmitter licenses in 50 different states, right? The existential threat to you is you lose money transmitter licenses in every state that has a Democratic administration, because they're not going to listen to your reason when you talk about your, tangible net worth or your one-to-one assets or whatever you're doing, right? And that's a problem in the digital asset space. It's a problem whether it's security or not. Conversely,
and just on that, just before we lose the thought there, it's not just whether it's a security or not. You have extensive consumer protection laws that could come into play that exist at the state level.
Absolutely, and that again aren't always well tailored to the digital asset space. In fact, are almost never well tailored to the digital asset space. And it used to be, even when there was an active federal government regime, you felt like you had more play to have conversation with your state regulators. We're seeing that change. Equally, so if you're not a security and you're a commodity, and we know the Commodity Exchange Act applies to fraud, you have a very interesting world right now with the CFTC, having gone below 600 employees. You think about this, directionally, the SEC has 4,000 plus employees, give or take, and the CFTC had 700, it now has 6, and they're directionally going to go down to maybe 500 employees, and the conversation is that they're gutting enforcement at the CFTC.
And before all of those cuts, the CFTC's Division of Enforcement had less than 200 people.
Right.
And across all people, not just lawyers, all people.
Right. So you have this world in which I project that you will see, and in fact, folks I know at the CFTC are like, we're not sending out subpoenas. We don't have, it's very different than SEC kind of business as usual land in many ways. what will that mean in the market, right? There is then a gap in the market, a gap in regulation that I think is one of those things you talk about. What will we be talking about next year, right? You will see the possibility of, a whole new line of fraud schemes and things coming in that aren't getting, that it's not a security, SEC is not dealing with it. And so it just poses we're in a very weird landscape. States are being very active. CFTC is likely to be very inactive in the near term. And the SEC has got a, I think, sensible, let's make some policy. So it'll be an interesting time.
So let's move on to our next topic, which is the way I was thinking about it was other regulatory classifications that touch digital assets that have been historically subject to SEC enforcement. So Brent, the high-profile dismissals of litigated actions against exchanges, we talked, that has been alluded to sort of extensively today, those touched a number of regulatory classifications within the SEC's orbit in the sense of like, exchange level or broker-dealer level type registration classifications. But I think there's one thing it hasn't really touched, which is at least something I know I paid a lot of attention to, which is the investment management industry. And especially now as crypto pricing has ticked back up, there's just a lot more demand. And, even in addition to, products that might trade out there, derivative style products, there's now a lot of exchange listed products that exist out there, ETFs and other instruments. And so just like maybe drawing a little bit from your days as an AD in the asset management unit, if you're an investment advisor or you're counseling an investment advisor running a digital asset strategy right now, like, does the Investment Advisors Act apply to any digital asset trading that you're doing at this point? Or is that back into the thing of to be determined, kind of like where are we? Patience?
I mean, of course, part of my answer has to be patience, right? Like,
facts and circumstances?
I'm saving that for the end. That's my walk-off, facts and circumstances.
That's right.
No, I mean, but look, so Commissioner Peirce expressly identified the impact of this process on the investment management industry and how this process could provide greater clarity. She identified 4 things. I'm going to focus on custody, but just to take them off, She mentioned disclosure obligations were a big one, best execution requirements, record keeping requirements, and then custody. And custody has taken sort of center stage. It was the focus of the third of 4 task force meetings so far. There's a much more detailed discussion, obviously, in the context of that third task force meeting that if people want to watch, you can watch it on sec.gov. But a few threads that I wanted to pull from that, which is earlier, so just stepping back just at a really high level, the custody rule has long played an important role in ensuring that registered investment advisors comply with certain requirements to safeguard their clients' assets. And I think of sort of particular relevance to the question that you're asking, that's included housing certain assets with qualified custodians. And obviously that's been part of the reason that got teed up for the third task force meeting is that's been a challenge to understand what qualified custodians, what that obligation means in the context of crypto. Earlier this week, Chairman Akin stated that he supports providing registrants with greater optionality in determining how to custody crypto assets. So I think that starts to lead towards you being able to sort of think about how to advise your clients.
That's a great speech, by the way, that everyone should read what he put out there.
And I will say a lot of my talking points are pulled from that speech, so I agree. And I'll just add one more quote from it just to point out how much I enjoyed it, which is that it's important to provide clarity on the types of custodians.
This is what you were reading to your kids?
They love this stuff. They love this stuff. And I'll just note the last part because I think it's the part that's important for your clients, like how you think about advising your clients, which is reasonable exceptions from the qualified custodian requirements to accommodate certain common practices within the crypto asset market. So this just gets at the point that the way that the technology, the sort of the mechanisms, the types of platforms that would be used, even the idea of self-custodying, those are the things that come up in the context for investment managers for crypto assets that maybe we haven't seen historically with traditional assets. And so it seems like, Chairman Atkins and the task force are going to be working on how to think about allowing, again, greater optionality within the confines of still making sure that investors are protected.
It's a special group of nerds that talks about how great a commissioner's speech is. And
We are that.
Look around, man. Like,
no, I'm just saying. I'm not. It's a group of nerds who are popular within this larger club of nerds.
yeah, there we go. There we go. Okay, so so we're coming up on the end, and I want to give everyone a chance. Just it's obviously a huge topic. A lot is going to be happening in 2025, and so maybe I'll just sort of work down the line here for some closing thoughts. So, Omid, trends that you're seeing. What are you thinking about? What do you see coming? What's on your mind?
Yeah, I want to go back to the lunch meeting. That was fun, right? That was intense. One of the things that was referenced was a TRM Labs report. So I'm a data guy, I'm a geek, so I'm going to give you some data points, and you guys are going to make your own decisions about the future of crypto and how the two speakers were talking about it. The report from TRM Labs said that in 2024, there were $10.6 trillion of transactions in crypto, okay? But it also said there was only 0.4% of that overall crypto transactions were illicit use of crypto. But that 0.4%, for those of you who are doing the math, is $45 billion. If you're one of those people who's impacted and lost money in that $45 billion, that's a lot of money. So again, there's, F. Scott Fitzgerald said it best, right? The sign of a first-rate mind is the ability to hold two opposing thoughts and still able to function. So that's my challenge to you. As you think about your clients, as you think about the future in this area, it's not going away, but there's still fraud. There's still, we created a whole task where we hired the former head of FBI from the Washington, D.C. office, who's a fellow partner of mine now, Steve D'Antonio. He set up a whole entire team that focuses on looking at crypto transactions and tracing them. So again, there's going to be a balancing act as we go forward in this area.
Trace, what are you seeing? What are you thinking?
Yeah, I would just add Oracle also has a blockchain offering, but we put that aside for another day. Listen, I think it's a really interesting evolving landscape. I think anyone practicing in the crypto space knows for the last 8, 9, 10 years, we've just been asking for policy. Like, come on, help tailor these clothes that don't seem to fit us. And we're going to see that, which is exciting. At the same time, you're going to see continued, DFS New York says we're going to business as usual, all right? You're going to see state enforcement at levels that we've not seen before, very aggressive, I think. And you're probably going to see new fraud schemes come up because of a lull in action by some of the regulators. But I think that's the way it almost always goes, right? The ebb and flow of regulation. Is it too much or too little? And we can never quite get the porridge the right temperature, no matter how hard we try, right?
Leavened bread, hot porridge. That's what we're looking for?
There you go. Absolutely.
And a bunch of nerds.
Yeah, a bunch of nerds.
A bunch of nerds.
Yeah.
Bunch of nerds. Brent,
Speaking of nerds, look, obviously this is to segue off the lunchtime panel too, but look, from my perspective, in the Los Angeles enforcement group, I think there still is very much a role for our enforcement program to play in this space, and I think it's a critical role. Where again, I've used this phrase, but I think it's the word that comes to mind most is serving as a complement for what the task force is doing on the policy side, and I think it's a critical role because we protect investors, we help retail investors when they've been harmed by fraud, and by doing that, we can be sort of a critical piece in sort of supporting the new administration's goal to support innovation in this space.
Well, it was an excellent discussion. Thank you to all three of you, and I do look forward to hearing this panel next year where we are. So thank you all.